We'll have your local forecast, but right...
Man, which Thomas Wolfe and Hart Crane wrote.
Hi, my name is Mansour, and after our second successful lecture, we have accumulated enough street cred to do a third one. This lecture, or this video lecture, is all about tattoos and copyright. In recent decades, tattoos have become more prevalent in our society, becoming another form of personal, cultural expression for those creating it and those who are wearing it. A cultural example would be a Moari tattoo. Also, tattoos are used for status,
Сука, блядь, пизда.
douchiness and fashion, a form of tribute to those that we love, a form of advertising, also a way to remember our youthful mistakes, and also to demonstrate to the world our personal statements about our beliefs. The legal ramifications of copyright and tattoos are not prevalent in English law. There are no examples as of yet. However, in America, fuck yeah! There have been some form of litigation. And there's this famous example between Mike Tyson.
And the first good left hook that Tyson landed, he dips under, throws this left hook. That's a nice move.
A tattoo artist named S Victor Whitmill and Warner Brothers, due to the film Hangover 2. One of the protagonists in Hangover 2 uses a tattoo that is similar or almost the same as Mike Tyson's tattoo. The presiding judge, I think Judge Perry, stated that there is a copyright issue involved and the tattoo does hold a form of copyright. And the parties that were suing one another was the tattoo artist against Warner Brothers. That's because Mike Tyson signed away his right to have copyright over his own tattoo and gave it back to the artist. However, Mike Tyson does still own the tattoo itself. For the sake of this video, we're talking about the actual tattoo. Who owns the copyright to the tattoo? We will assume that the tattoo would have met the minimum threshold to gain originality. In any work of art, there are two forms of ownership: the actual artwork and the copyright itself. Those who have tattoos, please do not worry, you still own your tattoo because it's physical ownership. The copyright is a different form of ownership in itself. So if we can imagine, let's say, the body and the soul. The artwork is the body, the copyright is the soul. So who owns the tattoo? As you can see in this graph, there are various possibilities in who can own the tattoo. There could be the tattoo artist themselves, the person that asked for the tattoo, or the combination of both. If it is the tattoo artists themselves, they'll need something in writing, like Mike Tyson's situation, to say that the person who got the tattoo is assigning over their copyright to them. That is because when, especially with tattoos, it is assumed that the person who purchases the tattoo and the person who wears it will have rights over the tattoo physically and its copyright as well. They have to give that copyright away, they must give it in writing. Another point could be seen that because of the relationship between the tattoo artist and the consumer could inadvertently take the whole copyright of the tattoo artist because it's seen as an employee and an employer relationship. Or finally, there could be a mixture of both, and that's the whole idea of joint authorship, and that's under section 10 subsection 1. We're going to assume now that the tattoo artist has the copyright, and under section 90 subsection 1 the client who has the tattoo has signed away the copyright right of it to the tattoo artist. But the whole way that we've dealt with it, assuming that the tattoo would have met the originality test, which I think it would, is that we're putting the horse before the cart in this situation. For the tattoo to actually have copyright, it must exist with one of the examples stated in section 4 subsection 2. So under section 4 subsection 2 states that a graphic work would include, or any graphic work would include, any painting, drawing, diagram, map, chart or plan, or B, any engraving, etching, lithograph, woodcut or work similar. The law has around this area been very, very strict in its application, and it's all to do with language. Two of the cases particularly we're going to talk about its merchandising and harp-on, and also the Lucasfilm case. My favourite case, the Adamant case, or well known as merchandising and harp-on, Lord Justice Launton stated that for a painting to have a copyright, we must look at the painting in its original meaning or natural meaning. And also, whatever work there is, or whatever surface it stays on, there must be some sort of permanence. In Adamant, he tried to use facial makeup and state that it has copyright, but the judge said, one, it was too simplistic, but two, most importantly, it didn't last long enough. It may last for 2-3 hours, but you cannot have copyright on something that has no permanence. A tattoo, on the other hand, will have some sort of permanence when you think about it. It lasts for many years and can actually subsist in that point. However, a tattoo is not a painting. It does not fall within its natural meanings. And one of the reasons why I'm raising this case is that it sets up almost a guideline towards what is said in section 4, subsection 2. That everything must be looked at its natural meaning and definition. Because of the Adamant case, or the harp-on, merchandising and harp-on case, under section 4 subsection 2a, no copyright or protection of copyright will be given to a tattoo because it will not be seen as a painting, a drawing, a diagram, map, chart or a plan. However, if we look under paragraph B or subparagraph B, and see any engravings, etchings, lithographs, woodcuts or similar work, the whole idea of similar work offers almost an entire species or an entire form of similar practice for tattoos to fall within it. Under Lucasfilm and Ainsworth, despite the case involving sculpture, under paragraph 118 of the High Court judgment, the 7 steps offered to the public or to the law in how to deal with these terms of art or terms of or these definitions is to break them down almost in a 7-way step and see if whatever word that we use, so for example engraving or etching, falls within it. However, as it fails in terms of matching its definition to etching and engraving, it can't meet these points, so I would argue it would not fulfill that point of copyright. Okay, that said, but we can assume that copyright does exist and there was a new definition created within the Copyright Act to include tattooing, and there is precedent in that, seen as a collage was given copyright or would have copyright, but is never mentioned within the definition stated in section 4 subsection 2, and that's stated in Creation Records Limited and Newspapers Limited. But the difference is it's quite a collages are seen as still very, very traditional and well known within the artist community, and it's still accepted as that. If copyright is given, and if the laws and the judges put in copyright within the definition of section 4 subsection 2, there will be another hurdle. Under that provision, it offers the courts a chance to not enforce a copyright due to public grounds, and this might be the thing that would prevent copyright from subsisting in tattoos legally. Reason being, it's a logistical nightmare. Imagine you have tattoo artists or agents of them running around the place asking people where they got their tattoo, Also, if the tattoo's an intimate place, could they show it or not, and that affects rights of privacy. The tattoo industry is not a large commercial industry, and everything done is almost done on an artisan process. Everything's quite small, everything's quite intimate and handcrafted and almost bespoke. So the whole idea of copyright being something used to prevent the mass production of one thing and to safeguard the artist's labour, it doesn't quite equate to tattoos. How do you enforce this breach of copyright? Who pays the damages? Is it whoever keeps the tattoo, you have to get rid of it? Or do you have to pay rent for that tattoo if you're the owner? Or maybe it's not the owner's fault, it should be the person that created it. Do they have to pay royalties for as long as the person has the tattoo to pay the breach of copyright to the person who had that copyright? It's a logistical nightmare. Therefore, I would argue that it will be not enforced by the courts. There may be copyright, but the courts would say no, because it's difficult to enforce, it's awkward to enforce. Tattoos will not have copyright in the UK, and there are various hurdles for that. Specifically, one, you have the hurdle of fulfilling or falling in within the language of Section 4, subsection 2. And as you've seen from the Adamant case and the Lucasfilm case, that the use of language and how strictly it is interpreted, it is not likely that tattoos would be seen as, or will not fall within that definition. Following from that point, if tattoos are seen to have copyright, they have the threshold of Section 171, by where the courts will see to impose that or not. But finally and fundamentally, as we stated earlier, there is a certain threshold for originality. Once that threshold is met, there's a completely new copyright. And this is the frustrating fact of the Tyson case, or the Tyson scenario and the Hangover scenario, with the tattoo artist S Victor Whitmill. And is that in English copyright law, it won't exist, or it won't have any backing, because when you compare the face of Mike Tyson and the protagonist in Hangover 2, they're different faces. The pattern might be the same in which is applied to their face, but the skill, effort and judgment that was made, or that allowed one tattoo artist to create an image of the face as compared to the other, is evident. And in that, to create an aesthetically pleasing tattoo that works within the contours of someone's body, creates a whole completely different copyright.
These cards anywhere?
No.
Never before?
Absolutely not.
What impressed you about them?
Well,
Thank you very much, and hopefully we'll see you for the next episode.
Wave goodbye to our friends. Until we see you again, this is Emily, and Brooke, and Paul, and mostly Elmo, along with a frug, saying, we bid you peace. Thanks very much.
We bid you peace!